Welcome to Weber Gallagher University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. My name is Chris Davis, a partner in the Pennsylvania Workers' Comp Department, and I'm presenting today with Patrick Cummings, one of our workers' compensation associates from our office in Philadelphia. If you'd like to view this webinar again, share it with others, or see other Weber Gallagher University programs, please visit the Weber Gallagher website, www.wglaw.com, and there you'll find copies of this presentation and others under the Weber Gallagher University page. Also, feel free to contact the firm with any questions at wglaw.com. Today's presentation is handling the difficult Pennsylvania workers' compensation claimant attorney. And with that, let's get started. Pat, welcome to the webinar.
Great to be here, Chris. How are you?
I'm doing great. How are you doing today?
Well, thank you.
Good. So one of the things I wanted to talk about is sort of, this is sort of an unusual presentation in the sense that, we're not going to be talking about case law or legislation, but rather techniques on dealing with a difficult workers' compensation attorney. And this started out, it had its genesis from a conversation I had recently with an adjuster who was talking about her difficulty in dealing with a local claimant's attorney and wanted to know what the rules and the parameters were for an attorney's conduct and how they can interact with an adjuster, how the adjuster can interact with them. So what we did was we put together a webinar today that's going to cover a couple different topics, and we're going to start off by looking at the ABA model rules of professional conduct to determine what the lawyers can and can't say. Also, we're going to look at the Workers' Compensation Act, the judges' rules, known as the special rules, as well as try to do some real-world tips and give you some guidance, if we can, regarding how to handle these attorneys. Names have been changed to protect the innocent. We're not going to try to name any names. We don't want to do that, but we want to give general guidance in dealing with claimants attorneys who practice workers' compensation in Pennsylvania. So with that, let's go to the first slide.
And yes, Chris, you discussed initially the first portion of our topic, which is the ABA rules. And specifically, the first rule we're looking at is 3.4, which deals with the fairness to opposing parties. In this case, that would be an adjuster. And counsel, that would be attorneys like Chris and myself. So that rule indicates that a lawyer shall not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document. It also indicates that a lawyer shall not counsel or assist another person, be it a friend or a family member, to do such an act. That rule also states that a lawyer shall not falsify evidence, counsel or assist a witness to testify falsely, or offer an inducement to a witness that is prohibited by law. And what we take from that, I believe, is that the workers' compensation community is one where we see the same claimants attorneys on a weekly and even daily basis. We deal with them on countless cases, and we try to let it be known as often as possible how much exposure we have to each other and how important it is to follow a rule such as Rule 3.4 because of the fact that you see them so often, and you wouldn't want to deal with a situation where it becomes angry or there's a combative environment you're dealing with. And the same can be said when we're dealing with claimants' counsel's dealings with opposing parties such as adjusters. I think claimants' attorneys know that in cases that aren't in litigation, if they have 3 claimants that they keep getting referrals from the same employer, they're going to likely be dealing with the same adjuster. And it is important to follow the rules, especially Rule 3.4, so that you can keep an open line of communication with that opposing party.
Right. So if you're an adjuster, I think it's important to know that the claimant's attorney is bound by these rules not to obstruct evidence, not to alter, not to destroy, not to conceal evidence, and also not to falsify. So if you get a sense in dealing with a claimant's attorney that they're doing any of these things, those are red flags. And those red flags, are going to raise alarm bells. And that is typically things that they are not permitted to do: obstruct, alter, destroy, conceal, and falsify. And you're going to see kind of those themes go along as we deal with other model rules. Rule 4.1 is truthfulness in statement to others. And what this rule basically says is that in the course of representing a client, a lawyer shall not make a false statement of material fact or law to a third person, or fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. So the takeaway from this slide is that the claimant's attorneys are not permitted to make any false statements of material fact or law to you. And they need to disclose material facts in order to avoid assisting a criminal or a fraudulent act. And fraudulent act comes up in workers' compensation because, for example, if a claimant is receiving indemnity benefits and then from an insurance company and also working on the side under the table, that is considered workers' compensation fraud in Pennsylvania. So it's important to know that the attorney that you're dealing with on the other side of the phone or on the other side of the email is not permitted to make false statements to you, as well as they need to disclose material facts relative to the case.
Sure, and if you see a situation like this arise and the case is not in litigation, it would be important to reach out to counsel to discuss. If the case is in litigation, it would behoove us to bring the workers' compensation judge into the fold and bring the matter to their attention, because they generally want to schedule a hearing quickly to address such an issue.
Right, and that's a good point. These rules are in place to govern attorneys' conduct, whether the case is in litigation or is not in litigation. That's sort of an important thing. Pat and I are governed by these rules 24 hours a day. And that we as lawyers are advisors, advocates, negotiators, and evaluators of cases, as well as a claimant's attorney. And it's important that, the adjuster knows that, hey, you're dealing with a person who is guided by these rules, and they should be, quite frankly, playing by the rules. Rule 8.4, misconduct. Is that your slide or my slide?
That's still yours.
Okay. So what we're doing with this slide is showing maintaining the integrity of the profession. And that rule basically states it's professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct. Also, it's a prohibited that they commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. The most important one, in my view, is the next slide, which is claimant's attorneys are not permitted to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And in a broader sense, they're also not permitted to engage in conduct that is prejudicial to the administration of justice. And the way I interpret that is, they can't be difficult. They can't be difficult to the point where they're, affecting the case in front of the workers' comp judge.
Turning a blind eye.
Or
right?
Turning a blind eye, right. They can be an advisor. They can be an advocate, but they can't act in a way that's prejudicial to the administration of justice, which is how the case plays out over time.
And kind of going back to what I said earlier with respect to the workers' compensation community, I think it is important to note that claimants' attorneys can tend to gain a reputation if they are kind of towing the line on attorney misconduct in Rule 8.4. If you get a reputation for that, then the handling of the claim becomes different. Then dealing with the claimant's attorney becomes different. And I think because of the nature of our practice, it's important to point that out if you see that issue, because even the claimant's attorney doesn't want that to become who they are and how they're defined.
Right. The catch-all of 8.4 is 8.4G, And I think it's very important to know that these claimants' attorneys cannot engage in conduct where he or she knows or reasonably should know that it's harassment or discrimination on the basis of race, sex, religion, national origin, your ethnic background, disability, age, sexual orientation, gender identity, marital status, where you are in the socioeconomic status. Any of those things are prohibited from an attorney, like a claimant's attorney, engaging in that conduct with you as an adjuster. If you feel that you're harassed, if you feel that you're discriminated against on the basis of any of these things, that is a very large red flag and something that should be either documented internally or you want to let your counsel know if you have an attorney on the case, because this is something that I think the lawyers self-govern themselves, and it's something that's very important to deal with in today's world.
Now, Chris, if a claimant's attorney violates one of these rules, what kind of recourse do we have?
So what happens is, if there's a violation of the ABA rules, typically what occurs is a referral to a disciplinary board. Every state has a disciplinary board. In Pennsylvania, it's the Pennsylvania State Disciplinary Board. That is manned by attorneys who act as sort of fact finders, and then it's also run by the Pennsylvania Supreme Court of Pennsylvania. If you get reported to the disciplinary board and it goes all the way up, you could potentially lose your license. You could lose your license for a year or 6 months or forever, or you could get suspended, and essentially, take away your livelihood. In addition, under the ABA rules, you could possibly get referred to criminal authorities under appropriate circumstances. Let's say that the discrimination is bad enough. Let's say that the harassment by the claimant's attorney is bad enough. There might be some kind of criminal intent there that could lead to some criminal charges being filed against them.
And I believe we just discussed some of the issues and misconduct in the rules that we abide by under the ABA standards. But as Chris stated in the beginning, there's also rules we must abide by in the workers' compensation setting. And the next slide addresses that in its section 1102, part 2 of the Workers' Compensation Act. And specifically, it says for a claimant's attorney or any attorney, there's an offense if the person does knowingly and with the intent to defraud any insurer, presents or causes to be presented to any insurer any statement forming a part of or in support of a workers' compensation insurance claim that contains any false, incomplete, or misleading information concerning any fact or thing material to the workers' compensation insurance claim. And kind of to sum that up, it's a pretty broad category of what they can deem to be misconduct under the Workers' Compensation Act. Where we see it applied most is in the form of a claim petition. That is, maybe they are grossly and knowingly inflating the claimant's average weekly wage that they list in the document. We also can see it in the form of an affidavit that the claimant completes. They have information included in that document that they know is not true, and they are presenting it to the court, signed by the claimant, and for the purpose of, let's say, denying supersedious in a case.
Right. So what's interesting about section 1102 was that when Pat and I put this seminar together, we looked at the Workers' Compensation Act as a whole. And if you ever printed out the Workers' Compensation Act, it's a fairly large document. What's surprising about it is that it really doesn't talk about a difficult counsel or a difficult attorney, except in this one section, which is section 1102, which is in the insurance fraud part of the Workers' Compensation Act. However, if an attorney is difficult, and difficult to the point of falsifying, presenting incomplete or misleading information, that goes to insurance fraud, and that leads to potential penalties, including civil fines and possibly even some criminal stuff. We get the police blotter, if you will. It's sent around by the Bureau of Workers' Compensation on a quarterly basis, the newsletter. And oftentimes you see claimants being criminally prosecuted by district attorneys for insurance fraud. But keep in mind that those penalties also apply to the claimant's attorneys as the statute is written. And there is the possibility of criminal penalties and civil fines associated with claimant's attorneys if they become too difficult, quote unquote, and too difficult from the point of falsifying information.
Sure. And another area where we do see or can see the potential for falsifying information, I think you deal with a situation like litigation costs, or you deal with a situation with respect to outstanding medical benefits. The nature of the business is that claimants' attorneys, for lack of a better phrase, tend to be in bed with some medical providers, and they have relationships with these doctors or chiropractors or therapy facilities, and it's oftentimes important to kind of review those bills, review the litigation costs to make sure maybe there was a prior round of litigation where the claimant was not completely successful and the judge didn't award the payment of litigation costs, and then the next go around they're attempting to include that. Unfortunately, it is something that we see on a not so infrequent basis.
Right, that's a good point. So we've looked at the ABA professional rules, and we've looked at the Workers' Compensation Act itself, and now we're going to transition into the special rules of administrative practice and procedure before workers' compensation judges. And these are the rules that the attorneys use every day. These they're called the judge's rules. Some people call them the special rules. They're administrative rules that are published by the Bureau of Workers' Compensation, and they give a roadmap to how a case plays out in front of a judge, and what the judge can do and what the judge can't do with regard to several different things, including, how do they handle a supersedious hearing? How do they handle the flow of the case? How do they handle subpoenas? But within these rules, there are specific rules that I think, and Pat would agree with me, applies to dealing with the difficult claimant's attorney.
Sure, and one area with respect to the judge's rules that has changed over the years is there is now a website. The Department of Labor and Industry has a website. Every workers' compensation judge across the entire state has to include on this website their specific rules in the handling of a claim. And quite frankly, I think almost every single judge handles the claim in a different way. And what I mean by that is there are some judges that claim petition is filed and you go to court and it's a pretrial hearing. There's no evidence taken. There's no documents submitted. Then you see another judge where they want the claimant to testify at the first hearing. And then there are judges that want the claimant to testify at the first hearing no matter what the petition is. It could be a utilization review petition. It could be a termination petition. They just want testimony. And it is important to know going into each judge who you're dealing with, in the sense that if we can provide our client with the insight as to how a judge is going to handle a case and whether or not claimant's attorney knows how the judge is going to handle a case, that can go a long way in kind of mitigating our exposure and the cost that goes into handling these claims.
Right, and it's a good point. I mean, one of the things to keep in mind is, there is no definition of a difficult attorney. What a difficult attorney might be in Philadelphia might be very different than what is considered a difficult attorney in Scranton, Harrisburg, or Pittsburgh. And when you know these judges' rules and you know them better than the claimant's attorney, you can utilize the rules on behalf of your client, i.e. the adjuster, in ways that takes away the difficult nature of the claimant's attorney, because the claimant's attorney might be being difficult and want to advocate to do A, B, and C, and then you turn around and say, well, judge, according to your own rules, you can't do any of that. So it diffuses the situation. It makes the claimant's attorney, takes him or her into a box and makes the case that much more controllable, which I think you want to do from a defense perspective most of the time.
Yeah, in one specific rule, and Chris and I will touch upon this under the tips section at the end. Um, Frivolous pleadings, that tends to be seen when you have a claimant's attorney who their main practice is not workers' compensation. And what that rule states that a judge can determine after a hearing that a petition or other pleading is frivolous, that judge may, upon their own motion or upon the motion by a party, issue a decision dismissing the petition or pleading, or issue some other decision within their own discretion. And the reason I bring up the claimant's attorney who does not often practice or does not specialize in workers' compensation is because we see a lot of cases where there may be a bureau document issued, the claim may be accepted but only on a medical basis, and you have a claimant's attorney who files a claim, a review, and a reinstatement.
Right.
They file all of them and just hope, throw it all against the wall, see what sticks, and see how much money they can get for their client or how many opportunities they have. And as we know,
but Pat, I mean, you're being too nice to the claimant's attorney. Oftentimes these claimant's attorneys use these petitions as a way of being difficult, right?
Sure, and I think it may be naive of us to think that they are simply trying to give themselves as many bites at the apple as they can. I agree. Sometimes they just have no idea what petition is the proper petition to file, and that, quite frankly, can backfire on them if you bring it before the proper judge. If you have a judge who is by the books, knows the rules like we're discussing today, that difficult claimant's attorney may actually hurt himself or herself in the eyes of the judge in valuing the case just based upon their frivolous pleadings.
Right. So I think the takeaway from this slide is, the judges have the power to address a frivolous pleading, and the judge can dismiss it on their own, or we can make a motion to dismiss it on your behalf. Many times these claimants attorneys, like Pat had indicated, will file them not knowing and being inadvertently difficult, or in my mind, maybe a little bit more cynical, they're doing this with a intent to be difficult in order to muck up the gears, so to speak, get things confusing, throw some red herrings in there. And we, through this rule, have the ability to deal with that. The other important special rule is Rule 131.54B, which is the manner and conduct of the hearings. And, that rule says if the participants or counsel are guilty of disrespectful, disorderly, or, Pat?
Contumacious
language. So contumacious is going to be the workers' compensation word of the day. And I'll get back to that in a second. The judge may suspend the hearing and take other action as the judge deems appropriate, including the submission of a written report to the director of adjudication together with recommendations. And this rule tends to really kind of tamp down on the claimant's attorney who is being difficult and out of hand, so to speak. Contentious is a Latin word. I had to actually look it up. Its adjective means to rebel against authority. So if you have a claimant's attorney who is rebelling against the authority of the judge, or is disorderly or disrespectful to the participants or counsel, so keep in mind that you have the judge, you have a claimant's counsel, the defense counsel. Let's say that you bring a witness to one of your employer witnesses to court, and the claimant's attorney is disrespectful or disorderly to that witness. A judge can stop the hearing and take other action, including writing up a report to the director of adjudication together with recommendations to sanction that claimant's attorney. And this is a powerful hammer against a difficult attorney.
Sure. And one thing I would just add to that is kind of the overall theme here in knowing when you have a difficult attorney. If you are going to, as Chris said, present fact witness testimony and you have a difficult claimant's attorney, make sure you do it in front of the judge and not by deposition, because I think if you do it by
It's a great
deposition, it feeds right into there. It's so much different seeing it in a transcript for the judge as opposed to seeing it face to face, and that really is how you can take a bite out of the claimant's attorney with this rule 131.54b.
So I'm not a big war story person, but I will share this one war story that I had a very difficult claimant's attorney that I was dealing with. And for the first couple of times that we would take depositions of fact witnesses by dep and also doctor's deposition, the claimant's attorney would modulate his voice to the point where he was yelling at the witness and basically conducting his cross-examination, screaming at the witness. And it never came through on the transcript. And it was done in an order to, intimidate the witnesses. Eventually what I did was I would get the cassette of the transcript from the court reporter. And on occasions, I would attach that to the actual transcript as we were submitting it. And claimant's attorney objected, and I said, Judge, in order to fully understand the evidence in this case, I think it's important not only to read the written response, but also to listen to the tape. And after about 2 or 3 times, that claimant's attorney changed his behavior because of my actions in submitting a tape, because he knew he couldn't get away with yelling at the witnesses any longer. So just a real quick war story there. The next rule is Rule 131.55C and deals with attorney's fees and costs. And like the slide before was sort of the judge's hammer, I think this rule is the claimant's hammer against adjusters or insurance companies. And this rule discusses quantum merit fees, unreasonable contest fees, which are basically, if a claimant's attorney can prove that there was an unreasonable contest, he or she can submit quantum merit fees, which are like 0.1, made phone call, 0.3 sent email to defense attorney, and they can recapture those attorney's fees because normal attorney's fees are paid out of the claimant's share. Quantum merit fees are paid on top of a claimant's attorney's fee.
And for that, they have to, as Chris said, 0.1, keep an accounting. They have to keep a time ledger and also include specifically what effort they expended and provide that in a written statement to a judge. That's the only way that they would actually be entitled to those fees.
And the difficult claimant's attorney, if they're really truly being difficult, will allege many times falsely that we are undergoing an unreasonable contest in order to leverage us perhaps to settling the case and submitting quantum merit fees in the amount of thousands of dollars, and basically taking the position either at a mediation or at the end of the case, hey, settle the case with me, or I'm going to pursue quantum merit fees. So that is a difficult attorney, but one that we have to take very seriously.
Sure, and Chris, I think you hit the nail on the head here, that the claimant's attorneys use this as a hammer because what they're really trying to do is they'll bring this up at the beginning of the case. They'll bring this up at the end of the case. There'll be absolutely no mention of it, and then you see it in their brief. And all they're really trying to do is pile on as much as possible in the effort to add value to the case or to increase what you're willing to pay, to avoid the situation where the judge does grant quantum merit fees.
The other thing that a difficult claimant's attorney will do is threaten penalty petitions. Not only threaten them, but actually file them. And in Pennsylvania, if a claimant's attorney files a penalty petition, it has to allege a violation of the act. Either, the ones that we typically see are, not investigating the claim in a timely manner, not paying indemnity in a timely manner, not paying medical bills that are reasonable and related, things like that. And in Pennsylvania, a penalty can have a substantial impact because the judge has a discretion of awarding a penalty from 0% all the way up to 50% of the compensation that's awarded. So let's say that a claimant files a claim petition and the back due is, $70,000 because the case has been in litigation for a number of years. If you get hit with a 50% penalty on top of that, that's $35,000. That's a lot of money. So that threat, if you will, is a real threat.
Yeah, and again, you'll see that a lot in settlement negotiations. You go to a mediation, if there's unpaid medical, a lot of times what you'll see is a tactic by a difficult claimant's attorney where, let's say, the claimant's average weekly wage is not that high. What are they going to do? They're going to really pump up the penalty petition, if one is at issue, to try and inflate the value of the case because it's being suppressed by the low average weekly wage.
And what dovetails off of the threat of penalty petition or the real penalty petition is the difficult claimant attorney then making the threat to subpoena your file, and also probably the greatest threat of all, which is taking your deposition or bringing you in live before the workers' compensation judge. The probably the good quote unquote difficult claimants attorney is probably not going to want to take your deposition. They want to inconvenience you. They want to ruin your day. They want to make things uncomfortable for you by bringing you in front of the workers' compensation judge and having you explain what you did on a file. That is something that we as defense attorneys are going to vigorously defend and avoid not only the subpoena for your file, but also the threat of taking your deposition or bringing you in front of a workers' comp judge. So this is the part of the show, if you will, where Pat and I want to talk about kind of some tips to take away with. We've talked about the model rules and the workers' comp thing and the Workers' Comp Act and the special rules, but I think these are kind of real world examples of tips that you might want to take away from this seminar. So I'll start off, and then Pat and I will kind of go back and forth. I think the first tip I had was was attitude, and attitude kind of goes both ways. You have the attitude of the claimant's attorney, and you have the attitude of the adjuster. And I would always encourage my adjusters to have a positive attitude when dealing with claimants attorneys, keeping in mind that those claimants attorneys are advocates, they're negotiators, they're evaluators for their clients as well. And their job, if you will, is to advocate for the claimant, but also your job is to advocate in some respects for the employer or the carrier. If you can have a positive attitude in your interactions with all types of claimants attorneys, I think that's a valuable tip to have. The other thing was grudges, and this kind of sparked a lot of conversation between Pat and I, because my general rule or golden rule would be don't hold a grudge against a specific claimant's attorney. And my rationale is that due to the high volume nature of Pennsylvania workers' compensation cases, you as an adjuster who probably might work in the insurance field for 20 or 30 years might be dealing with the same claimant's attorney over and over and over again. You probably have 10 files with that law firm. You might see them, for the next 20 years. If you have a grudge against a specific claimant's attorney, not only could it affect that particular case, but in theory, it could affect hundreds of cases over your lifetime and that claimant's attorney's lifetime.
Sure, and Chris, I think as you stated there, you see the same attorneys over and over, and especially you're going to mediations. You might be mediating multiple times in a week or a given day with a claimant's attorney. And even though they may be difficult, and it may be case by case, or that just may be how they handle their practice, it is important to know and realize that it makes our jobs easier if we can kind of look past that, so to speak.
And that kind of dovetails over, one of the other bullet points is big firm versus small firm. And I think it's very important for the adjuster to kind of have an understanding of the lay of the land in Pennsylvania. So what we currently have is, we currently have 3 or 4, I'll call them big firms, big corporate type firms who represent claimants. And they have offices in Harrisburg and Scranton, and they cover it statewide. they typically have, 4 or 5 partners and then a lot of associates. The other model that is currently in Pennsylvania that does workers' comp specifically is what I call the small firm or the solo practitioner. They typically have one attorney and one partner and 1 or 2 associates. That solo practitioner tends to be a little bit more difficult, if you will, than the corporate firm, because historically they like to do their own thing. They like to be a solo practitioner. They bring with them their own issues in dealing with it. And then the third kind of segment that we see is the what I call the dabbler. And the dabbler is sort of maybe a general liability attorney who has a small percentage of cases that are workers' compensation, or he or she is doing it for a friend, and they tend to be perhaps the most difficult because they really approach it with a general liability mentality, which is a little bit different, which is more of a slash and burn mentality that a lot of Pennsylvania workers' compensation attorneys bring to it. And also, they're more difficult and dangerous because they don't know the rules, they don't know the cases, they don't know the judges.
Sure, and actually, I'll go even one step further and break it down. The dabbler, as you called the attorney, they may not know the rules, but they're well versed in other practices and in litigation, and they could truly be difficult to deal with. They want to depose everybody. There's constant correspondences with the judge, and that's one way a small firm kind of handles some of these workers' compensation cases. Then you even have the attorney handling a case who has little to no workers' compensation experience at all, and that can be difficult because you're almost telling them how to do their job, but there are benefits to that. And there's benefits to dealing with all 3 of these different types of claimants attorneys we described. But when you have somebody who doesn't handle workers' comp, doesn't know the judges, it's important to see if the case is not in litigation. That's maybe something you refer to legal counsel to see if you can get maybe a better deal on trying to resolve the case, because opposing counsel isn't aware of the particular judge they're in front of. When you have the big firm that knows the judges, that knows how to handle it, that are collecting 20% fees from hundreds and if not thousands of clients, they can be difficult because unless you're really willing to talk settlement, maybe your correspondences or your phone calls don't get returned, don't get responded to. So they present, each of those different types of claimants attorneys presents their difficulties, and also there are benefits to dealing with each type of attorney.
Right. And I'll circle back to the beginning of this webinar and throw out Rule 4.2 of the ABA model rules, which is important to keep in mind. And that's the rule that says that if the parties are represented by legal counsel, a claimant's attorney can't contact you as an adjuster without our permission, as the defense counsel's permission. So keep that in mind when dealing with these claimants attorneys. They shouldn't, if the case is in litigation, or if a defense attorney is on the case, claimants attorneys shouldn't be contacting you to discuss the merits of the case. They might contact you because a claimant didn't get a check, or something with maybe an IME coming up, something very minor. But typically, and the rules that we deal with, they shouldn't be contacting you if the case is in litigation. Now, if the case is not in litigation and there's no defense counsel on board and you are unrepresented, then you're certainly free to discuss these cases with the claimant's attorneys, and keep in mind that the claimant's attorneys is going to try to get the best deal he or she can for the claimant, and you're going to be negotiating a lot of times, especially in the world of CNRs that we live in. We'll get the cases already settled by the adjusters. So you're going to deal directly with the claimant's attorney, and that kind of dovetails into the one thing, which is the tip associate versus partner. And I put that in there because I've seen claimant's attorneys, I've seen adjusters just really beat their head against the wall in dealing with a certain attorney at a certain firm. And sometimes it's better if it's an associate, a young associate who's trying to make their bones, so to speak, that sometimes the adjuster might be better served by going to that supervising partner or going to a different attorney within the firm to get a better result. Sometimes switching is better. And also, if the case is not in litigation and you're trying to negotiate a settlement, know your claimant's attorney and get to know them from the point of view of phone calls versus email. Some claimants' attorneys you can never reach by the phone, and you get disappointed and aggravated because they're not returning your phone calls. You view them as not participating in the process, and really, that's not their mode of communication. However, those same attorneys who won't talk to you on the phone might really, really love email. And in a world of today where everyone has an iPhone or an Android, you send them an email and let alone, next thing you know, you get a response. So sometimes it's important to know your claimant's attorney, know what he or she likes to do, whether it's phone calls or email, and let that be your guide.
Sure. And Chris, one other tip that we have up there that kind of goes hand in hand with your discussion earlier about setting cases up for settlement, and even earlier on in the claim, is the 20% fee agreement, or just whatever fee agreement that the claimant's attorney has with their client. And when we put up there, use the fee agreement as leverage, what we see and where you really can deal with a difficult claimant's attorney is a situation where there's a bureau document issued that starts paying the claimant. The claimant has retained counsel for one reason or another, but they're not on the fee yet. There's no fee agreement that has yet to be approved by the judge. And the reason that really can be a difficult claimant's attorney is because they're essentially working for free at that point. They are not getting paid. They're not getting their 20% taken out of the disability benefits being sent to the claimant. And it could be difficult to get a hold of them, like Chris said. It could be difficult to deal with them because they have 50 other matters that they're handling where they are getting paid and they are going to devote their time to. So it's important to see when you have that situation arising. And conversely, you could almost use it as leverage in a situation where the claimant is receiving 100% of the benefits for a period of time, and then the claimant's attorney gets involved. Maybe the claimant perceives that the claimant's attorney didn't even have to do a whole lot, but they got their fee approved, and they're now only receiving 80% of those benefits. And that 20% can mean a whole lot to a claimant. They may have their bills set up. They may have their living expenses set up. And when you alter that, even by 20%, that may be a situation where you kind of want to strike while the iron is hot and kind of see if they want to settle their case because their life is changing by 20% at that time.
Right. Pat, what's the last tip that we want to give today?
So the last tip kind of goes hand in hand with one of the earlier slides where we were talking about the powers the claimant's attorney has to request subpoenas for the adjuster's file and to bring them in to testify. The tip we have is to always, always, always leave a paper trail to avoid these certain situations. And by that we mean document your claim notes as early and as often as you can. And what that allows us to do is if the case gets into litigation and there are these subpoenas issued and they do want the adjuster to come in and testify, we can simply have you send us the claim notes. We would review them and redact them and send over all non-privileged information to claimant's attorney. That tends to go a long way with the judge. It shows the judge we're not hiding anything. If the claimant's attorney then continues to ask for testimony, the judges tend to get irritated at that situation and want to know specifically what the claimant's attorney wants. Is this a fishing expedition? Are you simply, what Chris said, trying to inconvenience the adjuster and have them take a day off from work, travel here, travel wherever the hearing office is to testify when their evidence is simply going to be what is in the claim notes? That's why we always say it's very important to leave a paper trail.
Right. So Pat and I would just like to thank you for attending this webinar. Certainly, there's many fact patterns that come up that we can address in the context of a webinar. But please, if you have any questions, reach out to Pat, reach out to myself, and we'd be happy to respond to you as quickly as possible. So thank you for attending our webinar, Handling the Difficult Pennsylvania Workers' Compensation Claimant Attorney. You can learn more about this program and all other Weber Gallagher events at www.wglaw.com/WG-University. Thank you.
Thank you.